Trump's defense files their final reply in the motion to strike the inflammatory language out of Jack Smith's indictment. Jack Smith is using a lot of bravado in this indictment. He's saying Trump is a bunch of things, like an insurrectionist and trying to undermine democracy and all the things. Well, Jack, there are criminal charges that you could have alleged if he actually did those things, and you didn't. You could have charged him with insurrection, but you didn't. If you would have charged him with insurrection, well, maybe you should have done that and then used the insurrectionary language to support the charge. But since there's no charge, why do you need the language? So Trump has tried to get this Judge Chutkan, to cross it out, get it out of there, because we don't want this inflammatory language going in front of a jury. We just want them to hear the facts. We don't need all the opining from Jack Smith. And so we're going to go through that filing. We're also going to take a look at another motion from Trump saying, Judge Chutkan, it is appropriate now for you to stay this case. Okay, there's no reason to continue prosecuting this until we get a resolution from the Court of Appeals about presidential immunity, executive branch immunity, and saying until that is resolved, this is all supposed to be just on hiatus. And so we'll see what Trump said there. But I want to share with you just briefly the court docket. This, of course, is the January 6th docket, and it is getting a little bit busier because we're going to start jury selection in February of 24 with trial in March. And you can see these are the two filings we'll be taking a look at, entered November 15th, and there's a bunch of other stuff going on. So the judge has said that there will be additional replies due and there are additional extensions of time. So we've got here November 22nd will be another deadline, and there will be more deadlines for more responses to more Trump motions to dismiss. And just for context, we're also expecting a similar slew of motions in the Florida case when the time comes. So this is what it looks like over in Chutkan's courtroom. This is Donald Trump's defense team writing, sending this into the court. We've got a lot of excerpts. This is from our friends John Lauro and Todd Blanche, as per usual, on this case. They say, Judge Chutkan, the prosecution, Jack Smith, falsely asserts that President Trump is, quote, responsible for the events at the Capitol on January 6th. Sounds like that's a pretty hefty allegation there, Jack. Can you prove that? However, the indictment does not charge President Trump with causing or participating in those events, nor could it, as not a shred of evidence suggests that President Trump called for any violence or asked anyone to enter the Capitol unlawfully. In fact, President Trump clearly and repeatedly called for, quote, peaceful and patriotic assembly, consistent with the finest ideals of our country. And President Trump also authorized over 10,000 National Guard troops, in fact, to prevent violence on January 6th, protection that was denied by Democrat Speaker of the House Nancy Pelosi and Democrat Mayor Muriel Bowser of Washington, D.C. Letters and evidence we've seen here from Stephen Sund, Capitol Hill Chief of Police, former, fired by Nancy Pelosi after he knew what was going on, and Mayor Muriel Bowser declined the National Guard in a letter that we've talked about here and reviewed many times. Thus, even these transparently partisan prosecutors could not obtain an indictment on that basis. So stop calling him an insurrectionist and blaming him for that stuff. Now, they say the prosecution, Jack Smith and the deranged thugs at the DOJ, they now seek to try President Trump for crimes that the grand jury never even charged, based on actions that President Trump did not take in a place he never was on January 6th, by people he never directed, and opposite to actions he actually did take and statements he actually made, all with the goal of inflaming and prejudicing the jury. Now, the prosecution, they say, Your Honor, may not do, though. So, allegation that third parties allegedly acted improperly, other people, not Trump, will only serve to inflame and to prejudice the jury and do not belong in the indictment against Trump. The court should strike them from the record. They say that President Trump also intends to move in limine, so before the trial, a motion to limit, to proscribe certain evidence, to preclude evidence, and it's preliminary motion, right? It's before the trial starts. We're going to move in limine to preclude evidence, to keep it out, relating to the challenged allegations. Now, the prosecution's opposition has previewed at least one basis for that motion, should it be necessary. And for instance, they say, Jack Smith claims that protesters were, quote, extraordinarily violent and destructive. Now, even if that is marginally relevant, which they say it is emphatically not, the danger of unfair prejudice and confusing the issues or misleading the jury would far outweigh any probative value of that statement. This is an important concept in the law, right? We don't want to mash together a bunch of issues. It's very difficult. In fact, one of the things that you do in law school is they teach you to spot the issues and tease out the issues, right? It's like one of the most difficult things for people to learn is what are all of the issues. You don't want to just presume you know what the issues are. It's called issue spotting. You have to spot them, pull them out, do the analysis on every issue. And sometimes what looks like a simple fact pattern, it's like this guy's mad at this guy. A is mad at B over a contract with C. And you go, no, it's way more complicated than that, right? There's 30 different issues with that guy's mother and sister and brother and 30 contracts and this one. It's complicated. So here they're saying, right, Your Honor, they charged him with specific conduct in the indictment and they alleged this is the law that was violated and this is the conduct that applies to the law that shows it was violated. When they add in a bunch of superfluous, unnecessary stuff, it literally violates the rules. There's a rule, Federal Rules of Evidence 403. It says that this is going to cause unfair prejudice by calling him an insurrectionist, confusing the issues. He's not on trial for insurrection. This is misleading the jury. You got a bunch of DC jurors who are going to go, what? Insurrection? They say would far outweigh any probative value. And so the fact that the prosecution even suggests that such inflammatory claims could be appropriate, it only underscores the unfair and the malicious way that Jack Smith is pursuing this case on behalf of the Biden administration against its leading political opponent, President Trump. All absolutely true, right? If you're a legitimate prosecutor who is trying to uphold the law and be even-keeled here without bias and without partisanship, you don't add in a bunch of additional language. Your case is strong. You know what it looks like. Like, for example, in a DUI case, okay, if you've ever known anybody who's been charged with a DUI, the charging document is just the document, just says DUI, right? And the report will explain the case. Police report might say this person was driving like a maniac and all that stuff. That's evidence from a witness, but it's not in the charge. If it's in the charge, then they charge it. That's reckless endangerment, right? Because this person was driving. So you charge it and then prove it. But you don't say like, this scumbag, in the criminal complaint, you put the charges there and then prove the charges. You can't add in a bunch of stuff. So they say Biden is now, right? A normal prosecutor would know this, and normal prosecutors do. They don't do this. And it serves to prove what a deranged thug Jack Smith and his prosecutors are. Now, here's the background. They say, Your Honor, on January 6th, President Trump was there. In fact, he spoke to a crowd of peaceful supporters that were gathered at the White House ellipse about 2 miles from the Capitol. And during his speech, President Trump acknowledged that after he was finished speaking, some members of the crowd would walk to the Capitol to, quote, cheer on our brave senators and congressmen and women, and, quote, Trump, peacefully and patriotically make their voices heard. They have this in a block quote from Trump saying the following: anyone you want, but I think right here, we're going to walk to the Capitol, and here's Trump, and we're going to cheer on our brave senators and congressmen and women, and we're probably not going to be cheering so much for some of them. Now, I know that everyone here will soon be marching over to the Capitol building to peacefully and patriotically make your voices heard. And like for the lefty, that's like code. That's like insurrection code. That means like pillage and plunder. So we're going to, says Trump, we're going to walk down Pennsylvania Ave. I love Pennsylvania Ave, says Trump, best avenue. And we're going to go to the Capitol and we're going to try and give. Democrats are hopeless. They never vote for anything, not even one vote. But we're going to try to give our Republicans, the weak ones, because the strong ones don't need any of our help. Saying we're going to try to give them the kind of pride and the kind of boldness that they need to take back our country. That's from Trump's statement. And NPR cited that. It's on their record. Peacefully and patriotically. They charged him for it. Now, President Trump made clear that he expected the electoral certification proceedings to take place. He also said that with Vice President and every congressperson and senator exercising their duties of their offices. Here's what he said. In other words, he did not encourage anybody to break up this counting. He expected it to go on because he wanted Mike Pence to do something differently. He said, and Mike Pence is going to have to come through with us. And if he doesn't, right, meaning that you are presuming that it happens, that the count happens, if he doesn't, not like Trump is saying, I'm going to stop him, that will be a sad day for our country because you're sworn to uphold the Constitution. And today we see a very important event though, Trump says, because right over there, right there, we see the event going to take place. And I'm going to be watching because history is going to be made. We're going to see whether or not we have great and courageous leaders or whether or not we have leaders that should be ashamed of themselves throughout history, throughout eternity, they'll be ashamed. And you know what? If they do the wrong thing, we should never, ever forget that they did. Never forget. We should never, ever forget. It sounds like Trump is presuming that it's going to be done, right? If they do the wrong thing, not saying we're going to insurrect the Capitol and take over the country. So President Trump also repeatedly opposed the destruction of monuments and other symbols of American democracy. And he referenced stiff criminal penalties for doing so. And he also signed these things into law. And he said this when he signed some other bill, right? He said, we signed a little law. He says, you heard our monuments. You heard our heroes. You go to jail for 10 years, okay? Everything is stopped. You notice that? It's stopped, okay? No more destroying our stuff. He expressed love for the United States and optimism about the country's future. He says, as this enormous crowd shows, we have truth and justice on our side. We have deep and enduring love for America in our hearts. We love this country. We have overwhelming pride in this great country. We have it deep in our souls. Together, we are determined to defend and preserve our government of the people, by the people, and for the people. He says, our brightest days are before us. Our greatest achievements still away. And both of these, again, these quotes come from his statement there. He said this in the same speech, it sounds like. And don't worry, we'll not take the name off Washington. We will not cancel culture. They want to get rid of Jefferson, but we stopped all of that. The Secret Service now, they say, and the FBI, Your Honor, Judge Chutkan, they estimated that at least 120,000 Americans gathered on the mall for President's speech. They have this here. Classified documents reveal the true number, according to Newsweek, estimated it at to be about 120,000. Now, Trump said 250,000. The J6 committee said the crowd at the mall was 53,000, right? So the committee wants it to be like small. So it seems like there's a high percentage of insurrectionists in the MAGA community where, it's not. It's, guys like Ray Epps and Christopher Wray's buddies. But it is 250,000, maybe a little high, right? Trump likes big numbers, and so they maybe round it up. But they're estimating it about 120,000. Got it. Now, they say they gathered in the mall. Government agencies estimated that about 1,200 people, at most 1% of the size of the crowd that was gathered to listen to Trump, actually entered the Capitol, and a smaller percentage than that committed violent acts. Footnote 7. Yeah, as few as 1% of the people were fit for the label of insurrectionists, which is also a joke, by the way, okay? And I always want to make this point because the number is really, really, really small. And I know if you don't have experience with like criminal cases and criminal numbers, it might sound like a lot. 1,200 people, that's a lot of people. It's not a lot of people. Just think about it in context of your local, government, right? How many tens of thousands of criminal charges are committed every year in a big city? A lot, right? In Arizona, it's thousands every year. And in big places like New York, it's tens of thousands a year. So this is just 1,200 people, half of whom have taken plea deals already, right? A big portion of those turn themselves in. My point is, you could have a Super Bowl weekend in your local area and you'll have 1,200 crimes, no problem. Okay, urinating in public, domestic violence goes up, DUIs go up. Think about this holiday weekend coming up, okay? Thanksgiving, look around your cities. There'll be 400 to 500 DUIs in the bigger cities all day, easy, right? 400 to 500 DUIs every year in the Phoenix metro area, no problem. And so think about that, right? And a DUI is actually, in my opinion, a lot more complicated than one of these cases. This is just a trespass case. A DUI is blood results and criminal lab testing and retesting and forensics. It's a lot. Are you there? Yeah. And most of the people even admitted it. So if you can have a state that can prosecute tens of thousands of crimes every year, and our U.S. Department of Justice is spending 3 years, essentially, right? We're on year, what is this? By 2024, we'll be in year 3 of investigations here. 1,200 cases, half of which have already pled guilty. Okay, the other half are like made up cases with, the Proud Boys and the Oath Keepers, that have a bunch of government witnesses there. So it's a very strange number. It's really, really minuscule is my point. Like this holiday weekend over the holidays, you'll see easily 1,200 additional surplus of crimes. And the DOJ is stopping everything, right? They've had full committee hearings. They're telling us is the biggest attack on the country since forever. It is like absolutely nothing. And if you just ask yourselves, I know I'm belaboring this point here. Let's say a normal attorney can handle a caseload of 50 felonies at any given time, right? And just do the math on that. Like just how many attorneys can handle 1,200 cases and over 3 years, right? At any given time with half of them pleading out. It's wild. So it's all basically fake as far as I'm concerned. It's fake numbers. Now there are people, the prosecutions are not fake. There are actual people being victimized by this, but they're being made to be a part of this bigger grand scheme. They're not. They're just people who are being abused by our government. So now thus we can easily conclude that over 99% of the attendees at Trump's speech did not engage in the events at the Capitol. Moreover, as the indictment recognizes, a crowd had gathered at the Capitol even before Trump had even finished speaking, further proving he had nothing to do with those events. And so recognizing a large crowd would be attending his speech, President Trump actually sought in advance to have law enforcement fully engaged and to mobilize the National Guard to ensure a safe event. This is a review from the Inspector General. He tried to get things situated. Now, according to General Mark Milley's testimony at the DOD, white rage guy, President Trump made a request for the military presence 3 days before January 6th. This is Mark Milley's testimony. Mark Milley and General Milley, according to this document, says they met with the president at the White House at 5:30. The primary topic they discussed was unrelated to the scheduled rally, but General Milley told us at the end of the meeting that the president told Mr. Miller there'd be a large number of protesters there on January 6th, a heads up, and Mr. Miller should ensure sufficient National Guard or soldiers would be there to make sure it was safe. General Milley told us that Mr. Miller responded, quote, "We've got a plan and we've got it covered." And they arrested Trump anyways for all of that, okay? And Mark Milley, by the way, was one of these whack jobs out there in the media saying that Trump was negligent and having phone calls, and kissy face with Nancy Pelosi in the aftermath, which is in violation of the direct line and chain of command to the commander-in-chief. Retired U.S. Army Lieutenant General Keith Kellogg also confirmed General Milley's testimony. Now, according to Kellogg, on January 3rd, 3 days before, the president asked the Defense Department to deploy the National Guard troops into D.C. for J6 contingencies. President Trump tried to ensure full security, but he was resisted by the mayor and the D.C. Democrat Speaker of the House, Nancy Pelosi. Other Democrat leaders did the same. Now, despite exhaustive investigation, the FBI found no evidence that President Trump was responsible for the actions at the Capitol. And just the opposite. After 7 months of investigation, a report revealed that the FBI has so far found no evidence that Trump or people directly around him were involved in organizing the violence. But tell that to MSNBC. Now, after investigating for more than 1 year, including by interviewing thousands of individuals and collecting hundreds of thousands of phone calls, text messages, social media postings, and other documents, the FBI still found no evidence connecting Trump to the actions at the Capitol. Despite many breathless stories and conversations in text and Secret Service meetings blaming Trump for the events of the 6th, there's simply no evidence to be found. Nonetheless, in April 2022, Biden directed his Department of Justice to prosecute his leading opponent for the presidency through a calculated leak to the New York Times by more than a dozen of his aides and allies. They published a story, they said, the Attorney General's deliberative approach has come to frustrate Democrat allies of the White House. It's talking about Merrick Garland. Why is he taking so long to prosecute Trump? At times, President Joe Biden himself has been frustrated. As recently as last year, Biden confided to his inner circle that he believed Trump was a threat to democracy and he should be prosecuted, according to two people familiar with the comments. This is the New York Times reporting, Washington Post reporting this, saying Biden has said privately he wanted Garland to act less like a ponderous judge and more like a prosecutor who's willing to take decisive action over J6. Now, this article is based on interviews of more than a dozen people, including officials in the Biden administration and people with knowledge of the president's thinking, all of whom asked for anonymity to discuss the private conversations. And so they're going to say, oh, no, Joe Biden never directed Merrick to do anything. No, he's just, waxing poetic around the White House. Oh, I wish I had a better attorney general. Gosh, I wonder what Merrick's up to. Oh, well, I guess I know something he's not doing. Prosecuting Trump. Oh, Mr. President, that's a zinger. No, of course not, right? This is the unspoken, unwritten order from the president. I would imagine it's much more spoken right now. They're not going to tell you that. They're just going to say, well, he wants him to stop acting less like a ponderous judge. The inner circle knows, half a dozen people know, a dozen people know, not half, a full dozen. They all know it. So within days of President Biden's directive to the DOJ, guess what happened? Those conversations take place and boom, the FBI opens an investigation into the quote electors scheme that ultimately resulted in this indictment, just as planned. So they get into some argument now. They say, Your Honor, it's pretty clear. Any references at the Capitol on January 6th from Jack Smith's indictment are not relevant to any of the charges he's been charged with. They say language in an indictment may be stricken. Take your big red pen out and get rid of it when it's not relevant and when it's prejudicial and inflammatory. They say the indictment here does not charge President Trump with insurrection, of course not, or incitement, or any other charge related to any actions at the Capitol on January 6th. The prosecution even admits this. In fact, they also conceded elsewhere that none of the charges against Trump include an element of an incitement offense. They're even acknowledging this. They say none of the offenses charged here, whether it's this one, or this one, has an element, any of the required elements for an incitement offense. Because incitement might go to free speech. And the elements of the charged offenses, defeating a federal government function through deceit, obstruction, through deprivation, are nowhere to be found in the elements or any other incitement type of an offense. So they say, Your Honor, look, it's easy. The prosecution has admitted that the incitement allegations that are littered throughout the opposition are not relevant to any of the charges. So they're saying Trump incited. But they say, even in their own filings, that the incitement is not there in their own charges. So nor has the prosecution explained how allegations about the J6 protest are relevant to the elements of the charges that it chose to bring. So there's no other explanation for them either. Indeed, they say the J6 cases relied on by the prosecution do not support its contention that actions at the Capitol are relevant and probative of the charged conduct. Several of the cases did not involve any of the charges brought against Trump. And so they reference other cases, but they say these things just don't apply. Meanwhile, the prosecution's false assertion that Trump is somehow responsible for the events that day is contradicted by the position taken by the DOJ in countless prosecutions of protesters who were present at the Capitol on January 6th. They say, well, in the other cases that you're prosecuting these J6ers for, you said that they couldn't blame Trump. They say, for example, consider this J6er, Dustin Thompson. In its cross-examination of Mr. Thompson, and he testified in his own defense, shout out to Dustin, the government emphasized that Mr. Thompson's actions on January 6th were his own, and they were not caused by anything Trump had to say. Because he says, no, Trump made me do it. And they said, oh, no, you did it, didn't you? Don't blame Trump. Trump's not responsible for this. They say, oh, okay, Mr. Thompson, this is the government. Now, you mentioned that you had, before January 6th, you mentioned that you listened to previous rallies of the presidents, right? I have. And after you listened to those other Trump rallies, did you go commit any other crimes? Trying to single this one rally out. Well, I wasn't attending any of those, but no. Okay, so the answer is no. You didn't go commit any other crimes? Correct. And notwithstanding that former President Trump was very passionate passionate during those other speeches, wasn't he? Yeah. And he said a lot of things about elections being stolen in those speeches, didn't he? Yeah. And again, when the former president, referred to the election as stolen during that time in those other rallies, you didn't do anything about it, right? I wasn't asked to. He didn't make any suggestions at that time on what to do about the situation, just that he wasn't going to concede and that he was going to fight about it. Okay. And so you had heard all those things before January 6th, right? Correct. And when you heard it on January 6th, none of it was new, was it? None of what was new? That he wasn't going to concede. You had already heard that before that day, right? Yes. And you had already heard that the election, that he had said the election was going to be stolen or had been stolen. He says, yeah, this is the last ditch effort. This is the way I looked at it. So the answer is yes. You had heard that before January 6th, right? Yes. And none of that was new to you on the morning of January 6th? No, I was aware of it. So the government proceeded to remind the jury, in this case, that President Trump did not cause Mr. Thompson to commit the crimes with which he had been charged. So you see this excerpt here is trying to blame this guy, saying, wait a minute, don't blame Trump, okay? You've listened to Trump many times before, right? Many other rallies, you heard it, you didn't do anything. But it was there on January 6th, and that's when you jumped in, and that's when you did something. He says, no, but I was there. And they said, okay, but you were there, but you heard him say things before, like, I'm not going to concede, right? And so on. Then in closing, they say, and so President Trump wasn't there standing next to you, was he? And President Trump didn't force you to go to the Capitol, did he? He didn't force you to walk every step of the way to the Capitol building, did he? And no. And President Trump wasn't standing right next to you at the doors to the Capitol building forcing you to go inside, was he? And you'd agree with me that not once during that hour-long speech did President Trump say it is now legal to steal from the Capitol building, did he? So they say in the government summation at trial, they specifically argued that Trump's conduct leading up to the January 6th was irrelevant. It had nothing to do with this. They said here, it is essentially irrelevant in this case what you think about President Trump's conduct on that day. We don't care. And so moreover, the government also said President Trump didn't hold his hand as he walked down the Capitol to loot and defile the Senate when he stole those things. And in another example, they took the Oath Keeper trial. Stuart Rhodes, they charged him with seditious conspiracy. Now, according to the indictment returned against Rhodes, they say Rhodes allegedly led this group before, during, and after J6 without any involvement from Trump. Specifically, at Rhodes's detention hearing, the court asked the government. They said, okay, is it the government's contention that had there not been a mob of people at the Capitol that day, say the Ellipse rally had simply ended, that there hadn't been a mob that marched down to the Capitol, would this group of individuals led by Mr. Rhodes, would they still try to enter the building even without the mob present? Like, we're trying to identify causation. Like, were they going to insurrect regardless, or were they just kind of caught up in the mob? The government says, Your Honor, the evidence is that they talked about the need to go to the Capitol grounds. And they say the defendant also made clear in the same message that President Trump must know that if he fails to act, we will. Okay, if Trump fails to act, we will. He has to understand that we will have no choice. So there is clearly, there were clearly messages that we have directly from the phone evidence that show an intent to be on the Capitol grounds, and intent to make those in Congress uncomfortable, and an intent to fight to stop them with or without somebody like President Trump calling them into action. They were going to do it anyways. And they say, we think it's critical, Your Honor, that the defendant, this is the government, is not only saying these words at the time, but also saying that these words are not contingent upon anything the president may do. In fact, he's suggesting the president thinks is not going to call the troops like the militia. Militia like the Oath Keepers are similar groups. So in summation, the government reiterated that the events on January 6th, during the trial, they said, happened despite President Trump, not because of him. In their closing arguments, some government prosecutor says, now to be clear, ladies and gentlemen, the government is not alleged here that as early as November, these defendants had their eyes on J6, because how could they? How did they know? But they had hoped that Trump or someone would intercede. But that these things has transpired, the way these things move forward, they knew that they would have to take matters into their own hands. They said Rhodes was clear in these open letters that if Trump didn't do something, they would. But guess what, they say? The government said this in their closing arguments. The president didn't take action. He didn't insurrect. No one did step in to throw out the results of the election and hold a new one. And so Mr. Rhodes and his co-conspirators had to spring into action. But now the prosecution is reversing course. And now they're dishonestly claiming that Trump is responsible, despite not charging him and previously denying his culpability. They say it's entirely specious. So, Your Honor, Judge Chutkan, the prosecution also does not deny or distinguish any of the cases cited by Trump. They cite multiple decisions where the evidence at issue is related to the actual defendant's other actions, not actions by third parties. The only case cited by the government is nonsense. But the prosecution here has cynically made January 6th the heart of the case, which is the opposite of the case that they cite. Now, finally, the prosecution pretends that relevance relevance has already been recognized. But contrary to the prosecution's claim, our motion to strike is consistent with other filings. It is true, as stated by both the motion to strike and the motion to leave, that the indictment raises certain allegations about J6, and we seek to remove those allegations because they have no authority for the suggestion that Trump is precluded from proceeding in the alternative by trying to collect evidence to defend himself against those unfair allegations. Now, had Trump not proceeded in parallel with those motions, they surely would have waived at least one of his options, and this is why we're left with this motion to strike. They say, Your Honor, the January 6 allegations are not allowed to prove motive or intent. Sometimes you can get in evidence to prove a different thing, and exceptions are motive and intent, and others. And as an alternative relevance ground, they say, well, it could show his motive and intent. Now, despite 3 pages of narrative, in other words, the indictment language could be used to show motive and intent, insurrection, blah, blah, blah. They say this argument is meritless. Despite 3 pages of narrative, the prosecution only suggests that one of the paragraphs that is subject to our strike does not show motive or intent, but to the contrary, it reflects protected speech by the president, and the fact that they try to get this in shows how far afield these claims are from the actual charges in the indictment. Now, finally, as a futile attempt to try to establish relevance, they say it's necessary for context. Last-ditch little context effort there. Nevertheless, they say, Your Honor, the prosecution did not charge Trump with any crime related to actions at the Capitol. Not insurrection, not incitement. The breadth of their indictment stretches far beyond providing context and background. Trump is not charged with triggering events at the Capitol. The prosecution carefully avoided that. Now, despite the lack of evidence, they now are trying to attribute guilt to the president for crimes that it did not charge, and it's doing it based on the actions of others. This effort causes unfair prejudice to Trump. It's not irrelevant. It's not context. They say here, prejudice has now resulted against Trump. Their reliance on these cases is inappropriate, and the voluminous evidence here shows that the jury pool has been already exposed to this indictment. They already think this is an insurrection charge, even though he's not charged with insurrection. This is another reason why this should be struck. And so, Chutkan, this indictment's allegations about the actions at the Capitol on J6 are not relevant. They do not involve Trump. They do not relate to the elements of any charge against Trump. They're inflammatory. They're prejudicial. Their purpose is only to attack Trump's character with false allegations that will require a mini trial for those and are collateral to the charges the prosecution actually filed. So Trump respectfully requests you grant the motion to strike and delete that from the indictment, signed by Trump lawyers John Lauro, Todd Blanche, on behalf of Trump. Now, there was another filing as well we'll take a quick look at here. This is Trump's filing asking for a stay pending a decision at the higher level court of appeals. They submitted this as well. Trump's defense says, Your Honor, this is President Trump's reply in support of our motion to stay the entire case. Pause it. Pending resolution of our other motion to dismiss based on presidential immunity. They say, all right, Chutkan. Police officers, correction officers, federal agents, executive officials, prosecutors, federal prosecutors, state judges, federal judges, members of Congress, all of these officials routinely obtain stays of discovery and other pretrial proceedings when they assert official immunity, pending final resolution of the asserted claims of those immunity. Now, the prosecution here, through Jack Smith, contends that President Trump should be the only official in America who is not entitled to the same considerations. Now, that position is meritless. The court should reject Jack Smith's arguments and stay all proceedings until there's a final resolution of Trump's claims of presidential immunity, saying Jack Smith concedes that the court should decide President Trump's claim of immunity ahead of other motions. In fact, they do not even dispute that the claims of immunity are subject to interlocutory appeal, meaning they are appealing it now. And they say here, as an assertion of immunity, however, this simple assertion protects Trump not just against going to trial, but against all the burdens of litigation. They say here, for the same reason, denial of a claim of presidential immunity. As explained in the first line of Trump's motion, the Supreme Court has repeatedly stressed the importance of resolving this quickly because denial is immediately appealable collateral order. You can immediately appeal it. Now, as noted, Jack Smith is not even disputing these things, but the prosecution ignores the reasons for these doctrines. Now, even though such reasons are stated just as clearly in SCOTUS opinions, SCOTUS emphasizes that immunity decisions should be decided as early as possible and are subject to interlocutory review appeal precisely because immunity provides immunity from suit, including all attendant burdens of litigations, not just immunity from trial or judgment. Meaning, look, what good is immunity if it's only the trial, but everything else you're having to suffer through? Immunity doctrines, therefore, ensure that officials are protected from the expenses of litigation, the diversion of official energy, pressing public issues, the deterrence of citizens from running from public office. This is a SCOTUS case from 1982, saying that the consequences prevented by official immunity include both the risks of trial and pretrial discovery matters. And so Jack Smith also concedes the latter point, but disregards the reason for the doctrine. The prosecution through Jack Smith envisions that this case should proceed with the discovery and all pretrial proceedings up until the morning of trial. Then, when it's time, Chutkan can say, immunity, and only be stayed the morning of trial if there has been no final determination of Trump's immunity by then. Now, the Supreme Court cases explicitly reject that view. Official immunity means the officer asserting the immunity should not be subject to either the costs of trial or to the burdens of broad-reaching discovery. That's why it's called immunity. In fact, the sole case that the government cites for this view contradicts the very point that they're trying to make. They say, in the case they cited, they say that immunity is designed to protect individuals from the burdens of litigations as well as the possibility of litigation. Now here, the burdens of litigation are huge. They're particularly acute, which Jack Smith conveniently ignores in its rush to judgment. This case involves 13 million pages of unclassified discovery. And my friends, trial is in March. Just do the math on that. Here, which we don't do here, discovery and hundreds of potential witnesses are also involved. That's pages, not to mention hours of surveillance footage. Okay, it is literally going to be impossible for Trump's team to review it all. It's impossible. It is also subject, if they put it all online, maybe we could all attend to it, but they're not going to do that. It is also subject to pretrial hurdles that can be caused by CIPA. So the cost, labor, the time of preparing this case for trial, especially with the highly compressed 7-month time frame adopted by this court, are staggering. It's like insane. It's like a lawyer cannot do a good job. You know, you see in the movies where they just like throw the guy in the lion's den, they like throw a lawyer at him. They're like, how do you plead? No, you're not guilty, Your Honor. And they like execute him anyways, right? It's like a token case. It's called a show trial. It's exactly what's happening in America. No way you can get through all of this in 7 months. Now, the Supreme Court instructs that Trump should not have to shoulder these burdens of litigation unless we've decided that he's not immune. And so the prosecution's argument to the contrary is totally meritless. So they say, Your Honor, in an apparent effort to prejudice the jury pool, the government recites inflammatory rhetoric. They make personal attacks on Trump. They attack his defense counsel, but they cite almost no case law. The few additional arguments that the government does make are unpersuasive. First, they repeatedly accuse Trump of trying to disrupt and delay proceedings by seeking a stay. Totally baseless. You're not trying to disrupt or delay. Stop using that conjugated language, that emotive language. This charge is baseless. Trump is plainly entitled to a stay of proceedings, pending a final determination of his immunity. He's entitled for this. He's not disrupting anything. Part of due process. To assert Trump's clearly establishment entitled as a disruption or a delay, it constitutes taking, does not constitute meritorious litigation. They also falsely contend that Trump attempted to unreasonably delay the proceedings by filing his motion to dismiss. How dare he? But they neglect to mention that Trump's exhaustively researched 45-page motion, while they did it all, while they're also seeking to review 13 million pages of discovery, thousands of hours of video and audio, responding to unreasonable demands for an immediate trial, dissecting which exculpatory information may have been illegally deleted and destroyed by the House of Representatives, investigating J6, dealing with efforts to wrongfully gag the leading candidate for president, addressing politically motivated efforts by the prosecution to interfere in an election, preparing extensive pretrial motions on various other issues on extremely compressed timeframes, and defending multiple other politically driven cases, including one brought by the same prosecutors involved in this case. We're busy! The suggestion that President Trump was somehow dilatory in filing his immunity motion early, well ahead of the deadline, reflects the desperation of the Biden administration's efforts in this political prosecution against their leading political opponent, President Trump. Now, finally, Chutkan, though the issue is not presented in this motion, the court prosecution contends that Trump's claim of double jeopardy is plainly frivolous, and the court should deem it so in writing. Now, presumably, they would personally attack Justice Alito for taking the very same position that Trump advances. Alito said this: the plain implication of the impeachment judgment clause is that criminal prosecution, like removal from the presidency and disqualification, is a consequence that can only come after the Senate's judgment and not prior to the Senate trial. In other words, as the Constitution explains, you gotta be impeached and then convicted, and then you can be indicted. In any event, Trump's defense says, the prosecution does not contend that President Trump's assertion of presidential immunity, the asserted basis for a stay motion, is frivolous, nor could it. Therefore, a motion for a stay should be granted. Signed here by John Lauro, Todd Blanche from Donald Trump's defense, and another very good motion. Now, of course, both of these motions are going to be denied by Judge Chutkan because she is not not going to allow any delay in this case because she's got her marching orders. This case is taking place in March before the primaries, and it is not going to move unless a higher court orders her to move it. No argument is going to be persuasive, in my opinion. Now, if the Court of Appeals comes out or there's some like mandatory reason for her to move it, she'll move it, but she's going to do everything she can to avoid it because she wants this trial to happen. I think that Fani has a very weak case. I'll be curious if that case happens before the election at all. And then the Florida case is looking like that's going to get bumped as well. So all their eggs are in this basket. They are going to keep this case anchored in hard. She's going to deny the inflammatory language motion because she's, thinks it's all relative and relevant. And so we'll follow this when her orders drop. We're going to have other replies from Trump later in November for his other motions to dismiss. So be sure you're joining us as we cover them. Thank you for subscribing to our channel wherever you're watching it. Thank you for sharing this content with a friend or family member so they can see really what's going on, right? A lot of these are Trump's defenses that we're just not hearing about in other parts of the media. And so thanks for inviting him over here so we can go through it together, and we'll look forward to seeing you on the next one.